Amid mounting legal debt, former President Donald Trump owes $456.8 million to New York State in penalties and interest for civil fraud. Trump must post a bond covering the full amount in order to appeal the judgment. New York's Attorney General says she would seek to seize some of Trump's assets if he's unable to do so by March 25th. Now, some on social media and others online are questioning whether filing for bankruptcy could get Trump out of paying those penalties. So let's verify using these sources. If a person or business can't pay its debts, they can file for bankruptcy and receive a bankruptcy discharge. A bankruptcy discharge is a permanent court order that releases the debtor from personal liability for certain specified types of debt, according to the U.S. Bankruptcy Court's website. However, under U.S. law, not all debts can be discharged. One of the most common types of non-dischargeable debts is debts to governmental units for fines and penalties, which is exactly what Trump is facing in this case. So we can verify, no. Filing for bankruptcy would not get Trump out of paying his civil fraud penalties. If Trump were to ultimately file for bankruptcy, the enforcement of that judgment against him wouldn't go away. It would only be paused during the appeals process, which would prevent the seizure of his assets. Unless he wins the appeal, Trump is going to have to pay up eventually. With your Verify, I'm Ariante Till.